Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. One of the previously under seal motions in limine filed February 24th, 2025 in the Idaho versus Kohberger case is motion in limine number 2 regarding vague and undisclosed expert testimony. This is a defense in limine motion, and we are going to see here as we evaluate this document that the defense is not only seeking to exclude certain what they refer to as vague and undisclosed expert testimony, but they're also seeking to strike the notice of DP. This is a very long, it's a 13-page motion in total, and you can read it for yourself by going to the link that I have provided in the description to this podcast episode. But just briefly, what the defense is arguing here is that because these numerous experts that they are seeking to strike have provided either vague or undisclosed testimony and or vague and undisclosed testimony, that this violates Mr. Kohberger's rights under federal and state constitutional law to due process of law, to the right to a fair trial, to the right to effective assistance of counsel, and the right to confront witnesses. Page 2 at the top says this motion is based on the 5th, 6th, and 14th Amendments to the U.S. Constitution and Article 1, Section 13 of the Idaho Constitution, as well as Idaho Criminal Rule 16 and various Idaho rules of evidence. And then he goes into the due process clause and what it requires. And then we get to the bottom of page 2. Mr. Kohberger requests exclusion and or limitation of the following expert testimony. Some of the names that we see here on the next several pages, there's 13 categories here, we've been exposed to as the public before. But then there's, again, a lot of new names here that the public is only learning about for the first time that the state has disclosed as their expert witnesses. And by way of example, I would like to direct your attention to page number 4 under paragraph 3, S3 and S4, that's States Exhibit 3 and 4. Mr. and Mrs. Barnhart, testimony must exclude everything other than specifically disclosed, including purported, quote, habit evidence. The state has not produced a report specifying what, quote, habits are referred to. No expert opinion has been disclosed. Now, who Mr. and Mrs. Barnhart are, we don't know. We don't know how they could possibly be deemed as experts. This information has not been disclosed either in any prior paper that has been open to the public or even here. And again, we don't know what this habit evidence has to do and what it is. Now, it continues on for the next several pages, other names of witnesses and why these expert witnesses must be struck or their testimony limited. And then we get to the bottom of page 8, where he states it is in the interest of fairness, justice, and judicial economy to exclude the listed experts. And he goes into first arguing that some of these were late disclosed. They don't allow the defense sufficient time to conduct follow-up investigation necessary and put the defense at a significant disadvantage. We go to the bottom of this document, bottom of page 12, just above Ms. Taylor's signature line. She's saying here, the court should exclude the listed expert reports and evidence listed above and preclude the DP at trial in order to cure some measure of the prejudice to Mr. Kohberger. We'll await to see what the state's response, which is due later in March, will say about this, and ultimately what the arguments are, oral argument on the 9th and 10th of April, and ultimately what Judge Stephen J. Hippler's ruling will be. So we'll now conclude this episode of the Indie Zone podcast. Thanks for joining us here today.